Thank you for joining me today. We're going to talk about arbitration and mediation. These are two ways to resolve your case other than settlement, direct settlement, and trial. Arbitration. Arbitration is where a decision maker decides your case who's not a judge. He's a kind of a private judge selected by both parties. Usually this person has particular expertise in the issues at hand, and he's trusted by both sides, or she. There's two basic types of arbitration in Oregon we're talking about. One is where the case is under $50,000, when you're alleging less than $50,000. Those cases are mandatory arbitration. You must arbitrate those cases. The courts don't want to deal with those smaller cases. That's why that rule exists. The other type of arbitration is arbitration that's required because of a contract. In the context of my practice, that's usually in an insurance contract. Typically, it would be where there's an uninsured driver and you have to make a claim with your own insurance company, or the bad driver does not have enough insurance and you have to make a claim for underinsured benefits with your own insurance company. Now, in the case of the alleging less than $50,000, those cases are appealable. That means either side can appeal an arbitration that's mandatory because there's less than $50,000 alleged. And if it's appealed, it goes right to a jury. Now, the other types of arbitrations are not appealable. In other words, if you have an arbitration under your own insurance policy, it sticks, it's binding. And that's an important thing to think about. Other than arbitration, the other main way to resolve a case outside jury or direct settlement is called mediation. And mediation is where the third party neutral does not decide the case. The third party neutral helps the parties come to a mutually acceptable resolution. It's usually not what either party really wants in entirety, but it's something that's palatable to both sides. And why do you need mediation at all? People ask. Well, in some cases, there's an inherent mistrust between the parties, and it's necessary to get a mediator in there to help bridge that gap, and it can be very effective. Mediators, the good ones, are trusted by both parties and really help to get out the points of view of both parties. Now, it also helps both parties prepare for trial, and that's a downside of mediation. You don't want to give too much away in mediation. For the right case, mediation or arbitration are effective and cost-efficient ways to resolve your case. I'm Richard Risk. Thank you for listening.